If you recently received something called an Appointment of Successor Trustee, then you might be a little freaked out. So we're going to start by talking about what that is, and by the time we're done here, you'll understand your options because you do still have some. But before we really get into it, there's a couple of things I'd like to get out of the way. First, no judgment here. You've got nothing to be embarrassed about. People find themselves in this situation through normal life events like losing a job, having a business go under, medical bills, things like a death in the family or divorce. So while you may be beating yourself up over this, do yourself a favor and try to set aside the emotional part of this as much as you can so we can focus on facts. Second, I'm not a lawyer and this isn't legal advice. I'm also not running a foreclosure rescue operation here, and I'm not wanting to buy your house. I'm just trying to be helpful. My name is Walt, and I'm a realtor with Murdy Associates right here in Springfield, Missouri. I've made it my goal to specialize in helping folks who find themselves in difficult property situations like probate or divorce, or, like in this situation, the possibility of foreclosure. This document is part of the foreclosure process on a mortgage that was originally set up using what's called a deed of trust. And whenever there's a trust, there's always a trustee. The original trustee was whoever handled the closing of the sale on the house to you. So somebody at the title company or a real estate attorney, somebody like that. And the deed is really just written proof that ownership was passed from one person to another person. So when you see an appointment of successor trustee, what's happening is the lender is replacing the original trustee with a new one. In most cases, it's a law firm or a foreclosure trustee company. They specialize in handling foreclosures. And that new trustee is the one that's going to handle transferring ownership from you to a new person. So in plain terms, this means the lender is getting things organized. But here's what it does not mean. It does not mean that the process is finished. Your home hasn't been sold. The bank doesn't own your house. You're not being evicted. You still own your home. What has changed is that the loan is no longer in a normal servicing phase. It's moved into the very first stage of formal foreclosure handling on the lender side. So don't assume the worst. The process is really just now officially getting started. At this stage, you're probably at least a few months behind on the mortgage, and the lender has decided they're probably going to need to sell the property to recoup what they can on the loan. That's why they've named a new trustee. Some states require a lawsuit and a judgment for a lender to foreclose on a house, but Missouri is not one of those states. Missouri is what's called a non-judicial state. And that means that the lender can simply start the process on their own. And that also makes the process quicker, so we don't want to drag our feet. The new trustee will at some point file a notice of trustee sale, and that actually sets the date of the auction. It needs to be recorded and published with enough advance notice to allow all the interested parties the opportunity to get their act together to be ready for the auction. And that includes you, but it also includes other interested parties who might want to bid on the house. And once you receive that notice, you have a definite timeline. Between the trustee appointment notice, which you've already received, and the sale notice, which is what's coming next, there's a window of time where a lot of things can still happen. We just don't know how big that window is at this point. So now is the time to contact your lender to try to work something out. Call and ask to be connected to their loss mitigation department. It might be called something else, but they definitely have a department like that. Once you connect with them, here are the questions you need to ask. First, what's the total amount needed to reinstate the loan? And have them give that to you in writing. That number will include the missing mortgage payments, of course, and late fees and maybe attorney's fees. The number might be a shock, so try not to let it upset you, but you do need to know that number. Next, are they open to a loan modification, a repayment plan, or a forbearance? And ask about partial claims or deferral options. If they're open to any of those, apply for all of those. You also want to ask if a notice of trustee sale has been filed or is scheduled to be filed. We're assuming no, not yet, but we do need to know for sure. And you might also want to ask about a deed in lieu of foreclosure, which is basically when you voluntarily give the house to the bank. There's a lot of reasons why that one doesn't work out, but sometimes when you're out of options, it's better than nothing. And lastly, ask them for a total loan payoff amount because that number may come in handy. Now, when homeowners are able to salvage a pre-foreclosure situation and save their house, it's usually because they've managed to get their feet back under them financially. Typically, they fell behind on their payments after a job loss, but now they're gainfully employed again. So, if that sounds similar to your situation, then your lender's probably going to be open to trying to work something out. But even if they're not willing, you may qualify for an equity loan, a refinance, or a personal loan large enough to bring the mortgage up to date and then chip away at that loan over time. If that sounds like your preferred course of action, give me a shout. I'll walk you through it in more detail. It usually involves private lenders. Now, if none of those options are possible for you, then it makes sense to try to sell the house before the foreclosure becomes official. And if you have some equity built up, even if you have to sell the house at a discount to move it quickly, you could actually walk away after the sale with cash in hand. And also, no foreclosure on your credit report. Now, this little window of time is your golden opportunity to try to make some magic happen. At this point in the process, you still own your home and you still have options if you take action. But a lot of homeowners hurt their chances because of how stressful the situation feels. When you receive a document like this, it's easy to want to set it aside, avoid thinking about it, assume there's nothing you can do. I get it, it's overwhelming. But avoiding it doesn't stop the process, and time is of the essence, because what determines your options now is how far the process has progressed, whether an auction date has already been set, and if there's enough time between now and whenever the auction is scheduled to take place. Every situation is different, but whatever path led you to the situation that you're in, I promise you it's not uncommon. The main thing is not to panic. It's important to understand where things stand because that determines what is still realistically possible, but you have to take action. If you're finding yourself in this situation right now, I want to leave you with this. An appointment of successor trustee does not mean that the situation is over. It only means that the lender has taken a formal step toward foreclosure if the problem with the loan is not resolved. At this stage, you still have some options and you have time to resolve it on your own terms. If you want help understanding what your specific situation looks like or what options might realistically be available based on your property, shoot me a text. I'll be here if you need anything. And in the meantime, take some deep breaths. I know it feels overwhelming, but it's going to be okay.